commerce with all nations, alliance with none should be our motto. That's how Thomas Jefferson put it. He was far from alone. This was a very common view among the founders, but they didn't make this up on their own. They didn't get it out of nowhere. And so today I'm going to share with you the top 5 people who influenced their approach, their pantheon of war and peace, foreign policy, and international law. I've got some highlights of those views and some from the founders that track that pretty closely as well. I think you're going to find this interesting and see if we can apply some of these views for today. We're going to do our best, of course. But first of all, welcome to the show, and thank you for joining me here on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the show for, what is this, May the 8th, 2024. Let's get right to it. Here from an article by Rob Nadelson. He points out that you may have heard someone say the Constitution was written to be understood by ordinary people. That's mostly true, but it's true only in context. Most of the framers and leading ratifiers were lawyers, and the ordinary people they addressed were the members of the American public during the late 1780s. We have to keep that in context while we want to understand parts of the Constitution or any of the Constitution. That was a time in which the general public was far more conversant with law and policy than the public is today. Now, Rob says, I don't want to suggest that understanding the Constitution is an exercise in obscurantism, performable only by a few experts. On the contrary, understanding the document is well within the abilities of the average literate American. But as is true with any specialized writing, you do have to acquire some background. And for that, it makes me think of Abigail Adams in a great letter that she wrote to her son, John Quincy. He was pretty young at the time. And she said, learning is not attained by chance. It must be sought for with ardor and attended to with diligence. So many of the Constitution's expressions were basically legal terms of art. They were derived from 18th century law, even further back. In other words, they carried very specific legal meanings. And he said some of these legal terms of art, Rob writes, appear in what constitutional lawyers today call the Define and Publish Clause, for example. That's Article 1, Section 8, Clause 10. This provision gives Congress power to define and punish offenses against the law of nations. And what is that? That's kind of what we're getting into today. The law of nations was the usual 18th century term for international law. Nations included not only sovereign countries, but also non-citizen foreign ethnic groups within sovereign territories. We often heard discussions in the Washington administration with the Secretary of War, Henry Knox, and others about possibility of needing to declare war against the Creek Nation, for example. So that's an example of that. The law of nations, Rob writes, consisted of standards governing international conduct. And the Define and Publish Clause is one of several of the Constitution's references to foreign policy and international relations. So during the 17th and 18th centuries, there were a number of top scholars, but there were 5 of them who were considered on international law, foreign relations, war and peace to be the experts, the pantheon of that group. And in 1783, the Confederation Congress put together a 3-person committee of James Madison in Virginia, Thomas Mifflin in Pennsylvania, and Hugh Williamson in South Carolina to organize a set of books for Congress to learn. And this is not the type of stuff that they learn today, but they certainly should at least look. It's still published in the Congressional Record. The committee recommended that Congress purchase the works of all of these 5 experts, plus a number of others. The list here will be linked to in the show notes. There's like 300 some odd books in various topics, but on law of nature and nations, we get these 5. And here from Rob Nadelson, he said the first of these scholars was Huy de Groot, more commonly known by his Latin name, Hugo Grotius. He published The Law of Nature and Nations back in 1625. And today he's recognized as the father of modern international law. Very little of what his approach was is followed today. But the other 4 authors were Samuel von Pufendorf, Christian Wolff, both Germans, Jean-Jacques Burlamaqui, a professor at the University of Geneva, and Burlamaqui's most famous student, Emmer de Vattel. Now, we often hear people call him Emmerich, but Rob points out that that's incorrect. His name is Emmer de Vattel. Now, so To the founders, these 5 made up the international law, the foreign policy, war and peace pantheon, the experts. Lawyers and judges cited them regularly in the early parts of the Republic and before the Constitution was ratified. Most of them were discussed and cited during the ratification debates. Vattel was cited the most, more than any of them, and I'm going to get to some reasons why a little bit later in the episode, but some highlights on the others first. First, from Hugo Grotius. Again, he published on Law of War and Peace in 1625, and here's a little bit of what he put. Throughout the Christian world, I have observed a lack of restraint in relation to war. Sounds familiar. I say that a lot when I look at this historical stuff, and I think that's why it's so important. Even though history doesn't repeat, the saying goes, it certainly does rhyme. So if we want to understand how things might play out in the future, we certainly have to understand how similar situations played out in the past. The founders actually took that approach pretty regularly. So throughout the Christian world, I observed a lack of restraint in relation to war, such as even barbarous races should be ashamed of. So he's looking at the so-called peaceful Christian West, and he's saying these people have been acting absolutely horrible, worse than the barbarians. I observed that men rush to arms for slight causes, or no cause at all, and that when arms have once been taken up, there is no longer any respect for law, divine or human, just wanton destruction. It is as if, in accordance with a general decree, frenzy had openly been let loose for the committing of all crimes. And we can see this type of mentality in James Wilson in his great speeches in the Pennsylvania Ratifying Convention. For example, he says, "This system will not hurry us into war. It is calculated to guard against it." So if Grotius is talking about how everyone's rushing to war all the time, they learned the horrors of this. They watched it, they saw it play out, of course, in their own experience, but this is part of their educational canon, that it's bad to hurry into war, so they created a system that is at least supposed to guard against it. And here also from Wikipedia, which has got a decent overview on Grotius. His treatise, published in 1625, advances a system of principles of natural law, which are held to be binding on all people and nations, regardless of local custom. The work is divided into 3 books. Book 1 advances his conception of war and natural justice. He makes the case that in certain situations, war is justifiable. He has a just war theory. Book 2 identifies these 3 just causes for war: self-defense, reparation of injury, and punishment. Now, it's not just, hey, we're going to punish you for speaking out improperly. You can read through the whole thing to get some details on this. Grotius considers a wide variety of circumstances under which these rights of war attach and when they do not. Now, Book 3 takes up the question of what rules govern the conduct of war once it has begun. And so here's a couple of examples. He said, "It has already been proved that when our lives are threatened with immediate danger, it is lawful to kill the aggressor if the danger cannot otherwise be avoided." Now, he's talking about interpersonal relations here and what he calls private war here. But later on I think in Book 2, this is from Book 1, later on in Book 2, he basically says, look, we can have the same mentality. If it's a group of people taking the same approach, we have to apply these same principles. We can even think of people like Spooner, who says, centuries later, who basically said, if an individual can't do it, you can't authorize a government. Or this is actually Bastiat. If you can't authorize an individual to do something, it's also a crime to authorize government to do the same thing. So Grotius has a kind of a precursor on this when it comes to self-defense. It has been proved that when our lives are threatened with immediate danger, it is lawful to kill the aggressor if the danger cannot otherwise be avoided. Now, he's not wanting to rush to arms for every slight. You have to avoid the danger in every situation possible, as much as possible. He said, "We must observe that this kind of defense derives its origin from the principle of self-preservation." The founding generation, the old revolutionaries, so often talked about the first law of nature, whether it was James Wilson or Samuel Adams or Mercy Otis Warren. They all referred to the first law of nature, which we could either cite, depending on who's talking about it, the principle of self-preservation, or the right of self-defense, which is naturally derived from that, as Samuel Adams put it. Anyways, we must observe that this kind of defense derives its origin from the principle of self-preservation, which nature has given to every living creature, and not from the injustice or misconduct of the aggressor. So your right of self-preservation you don't derive that from what the aggressor decides to do. You have it no matter what anyone else has to say. It is your take. And then he talks about some views of how to make a war just, or what is a just war. He said, to make a war just, according to this meaning, it must not only be carried on by the sovereign authority on both sides, but it must also be duly and formally declared, and declared in such a manner as to be known to each of the belligerent powers. Now, certainly the form of declaration and the custom of declaration changed over time, but certainly it must be declared by the sovereign against another sovereign in order to be a just war. Without the declaration, it doesn't count. And if you think about in modern practice, they don't really declare war anymore. They don't follow Article 1, Section 8 of the Constitution. They just pass the buck. Maybe the executive branch is in essence declaring war by their actions, but that's not according to the rules that have been prescribed or delegated in the Constitution. But here's how John Jay, as the first Chief Justice, put it as well. He said, this is a charge to the grand jury in Richmond, Virginia. He said, until war is constitutionally declared, the nation and all its members must observe and preserve peace. So Grotius also talks about justifying attacks. He said, to justify an attack upon a sovereign power for the aggressions and debts of its subjects. So if you got a bunch of residents of a particular country committing crimes against the people of your nation, we can think of many examples of that in modern times, but this has happened all through history. Do you hold the entire nation to be punished for that? Well, you can justify that, but you have to go through a process. To justify an attack upon a sovereign power for the aggressions and debts of its subjects, a previous remonstrance and a proper demand of justice must be made to that power. So you first have to go to them and say, hey, turn these people over, or punish them according to your laws, if you can find them guilty, whatever that may be. For it is only by refusing to punish the guilty or to grant indemnity to the injured that states or sovereigns can be implicated in the misconduct of their subjects. So next up we have Samuel von Pufendorf, who wrote The Law of Nature and Nations in 1672. And this work took largely the theories of Grotius and many also from Hobbes, adding to them Pufendorf's own ideas to develop a law of nations in the late 17th century. He also challenged, this is from Wikipedia, he also challenges the Hobbesian thesis of a state of nature, which is a state of war. So Hobbes is basically saying everything is always kind of in an eternal conflict. It's a precursor to the Trotskyite view of more modern times. For Pufendorf, there too is a state of nature, but is a state of peace. Our natural existence is to be in a state of peace with each other. It's not always to be attacking. It takes aggression. It takes a different mentality and approach to do that. So the original form of things is to not be in conflict. He adds that international law should not be limited or restricted only to Christian nations. This was certainly an argument at the time. And if you think about what Grotius had to say about how the Christian nations were waging war, it was so barbaric that even the barbarians would have been embarrassed by it. But it must be created a common link between all peoples, since all nations are part of humanity. And here from my buddy Joe Wolverton, who's done a lot of really great work on these influences of the founders. He used to call it the founder's recipe. I think it's pretty awesome. Pufendorf's magnum opus, published in 1672, is his most enduring work. In this piece, he articulates his vision of a society governed by natural law. And we can see how the founding generation, they liked the foreign policy messages and the international law treatises from people who were on board with natural rights, the right of self-preservation, the right of self-defense, natural law, etc., where individuals' rights and obligations were grounded in reason rather than arbitrary authority. And of course, we know arbitrary power that a government exercises beyond the limits given to it. That is the definition of what the founders called a tyranny. It's listed as one of the injuries and usurpations in the Declaration of Independence. So Joe continues, his works informed the thinking of American diplomats such as Benjamin Franklin and John Adams, who were instrumental in securing international recognition for the U.S. during and after the American Revolution. And he says his ideas about the community of nations and the necessity of peaceful coexistence among states. If you think the state of nature is a state of peace, according to Pufendorf, it helped shape the foundations of modern international relations and diplomacy. Well, at least how it's supposed to be, according to the founding generation. George Washington, Thomas Jefferson, when he was talking about the motto of American foreign policy, he certainly was just reiterating what President Washington had to say, for example, in his farewell address, where he said, "Observe good faith and justice towards all nations. Cultivate peace and harmony with all." Now, of course, Jefferson, Washington, the others, Jefferson called on Congress to authorize him to wage war against the Barbary pirates. George Washington repeatedly asked Congress for authorization to fight back against various Indian nations. So they weren't opposed to using force, but the primary goal should have been, the primary tool of diplomacy is one of peace and commerce. Back to Pufendorf. You can get the full text of it. Man, I don't have too many more highlights because there's a lot of really good stuff on this, but I will link to the full text of this in the show notes. Alan Mosley will get that organized like he does for every single episode. Thank you, Alan. You're awesome. We have, for every episode, there's a blog post where you can find all the different platforms we're on. Plus, there's a show links section so you can read the stuff that I'm talking about in context and learn more on your own time, because I'm really, really just scratching the surface with all this stuff. Anyways, I want to say a quick hello to everyone out in the live chat. I really appreciate you being here. There's the Ron Paul Liberty Report crew over on Rumble, Sarah, Brewster, Gypsy, Render, Dennis, C. Min in Tennessee, and a few others. I appreciate you being here. And then over on YouTube and Facebook and X, there's John and Kirk and Dixie and Howard and Haji, and I'm just scrolling as fast as Slam Barnhill in Raleigh, North Carolina. Thank you all for being here. Again, whether this is your first episode or you've been here for every single one since day one, I can't thank you enough. I hope you're enjoying the episode so far. We've got a lot more info to go. Here from a long paper by Rob Nadelson on... what is this one? On the Define and Publish clause. He points out that Grotius, so we've gone through Grotius and Pufendorf, their volumes were being sold in Philadelphia as early as the 1740s. He said, surveys of American 18th century libraries show that books by several of our authors were very common holdings, these top 5. Pufendorf's work was tied for the 10th most common holding among law books in libraries in colonial pre-1776 Virginia, and leading founders relied freely on the authorities considered here. Thus, in the course of his 1774 essay defending the rights of the colonies against Great Britain, I should cover this in an episode on its own one of these days, John Dickinson cited Grotius, Pufendorf, and Burlamaqui. I'm sure I'm pronouncing that incorrectly. But Joe Wolverton discusses Jean-Jacques Burlamaqui as well. He said he was familiar with the works of Pufendorf, and you can see how this lineage kind of builds on each other. As he was a disciple of Jean, whoever, I can't read this name, the eminent editor, the editor of Hugo Grotius and Pufendorf. So he was a disciple of a guy who edited both Grotius and Pufendorf, and he was encouraged to actually do a lot of research and learn more and build on these things. His words and the spirit of his explanation of the laws of man and nature, Joe writes, were digested and then quoted liberally by James Madison, Thomas Jefferson, and the like. In fact, all of our revered founders eagerly gleaned insight from the pages of Burlamaqui's magnificent contribution to the natural law canon. He really only published one book, I believe it was in 1747, just before he passed away, and he really felt that his work was best done through lectures. He was a professor, and so some of his students actually organized some of his notes and then expanded on his work and published it through his notes a few years later in 1751 after he passed. From my understanding on the reading of this, his sister and daughter, I think, maybe mother and sister, they both said, well, these aren't exactly his words, so we don't necessarily endorse this, but that's some side drama. Anyways, Joe continues. He said, of all of Burlamaqui's American students, Thomas Jefferson was probably the most devout. And just a quick side note, this was where Jefferson and also James Wilson, they were influenced, instead of using to life, liberty, and property, they were influenced by Burlamaqui to use life, liberty, and happiness. You can learn more about that elsewhere as well. But back to Burlamaqui, he says, we must observe that the natural state of nations with respect to each other is that of society and peace. Again, peace, commerce, honest friendship, that is the natural state. That should be our starting point at all times. Now, we know there are a lot of hostiles out there. And I would say, personally, as a quick aside, the worst hostility that we get towards our liberty, our prosperity, comes from, well, what's supposed to be our own representative government. So that's a side note. So having them to kind of defend us doesn't make a lot of sense to me. So we must observe that the natural state is society and peace. That society is likewise a state of equality and independence. I just recently did an episode on the foreign policy of George Washington and Thomas Jefferson, and they really, if you really think about George Washington's foreign policy, which Jefferson really pushed forward, the foreign policy was based on the Declaration of Independence, because as Washington said in his farewell address, a nation which has a habitual fondness or habitual attachment or hatred for another nation is in some ways a slave to that nation's interests, because they may change things. So if you have a permanent alliance with them, you're going to be basically not fully independent. So you're actually rejecting the Declaration of Independence through permanent alliances. Anyways, it's equality and independence, which establishes between them a right of equality by which they are obliged to have the same regard for each other. The general principle, therefore, of the law of nations is nothing more than the general law of sociability, which obliges nations to the same duties as are prescribed to individuals. And if you think about what Bastiat said in 1850, this is the same type of message. If an individual isn't supposed to do this, why can a collective group of people have the same authority? That is not founded in any solid principle. Here's Thomas Jefferson's take on this from his first inaugural address. Peace, commerce, and honest friendship with all nations, entangling alliances with none. Our friend Brian McClanahan is repeatedly talking about Jefferson's first inaugural as basically the definitive speech on American government and American policy for the first part of the Republic. And he also cites, I think he's mentioned a farewell address as being awesome. Jefferson, of course, thought that as well. But he really, really hammers home on the importance of Jefferson's speech. I did an episode on it a couple of years ago. Maybe I should reiterate that because I keep hearing that. Brian's one of the daily podcasts that I listen to, so I keep hearing that from him and gives me an idea to do another episode. Anyways, back to Burlamaqui. He said, from the principles here established, we may conclude that every just war must be made either to defend ourselves and our property against those who endeavor to injure us by assaulting our persons and by taking away or ruining our estates, or to constrain others to yield up to us what they ought to do when we have a perfect right to require it of them, or lastly, to obtain satisfaction for the damages we have injuriously sustained, and to force those who did the injury to give security for their good behavior. Now, he went through a bunch of examples. Again, I'm scratching the surface, very brief highlights. These are very, very long books. But some of the translations are pretty easy to read, not as difficult as some of the other things I've cited. He gave a bunch of examples of what does not count as a just war, what he called an unjust war. He said, for example, to have a just reason for war, it is not sufficient that we are afraid of the growing power of a neighbor. So if someone is arming up on your border, that does not mean you have a right to just go kill them all and destroy their self-defense because maybe they have their own reason. Maybe they think you're a threat. So they have a right to be as armed up as they want. The notion of gun control, just because someone has more guns than you, is really, really a slippery slope, a dangerous mentality. We don't think, well, at least you and I don't think that if someone has a bunch of so-called assault rifles, which is a terrible name for it, that we should have gun control just because I've decided not to have such a thing or you've decided not to have such an item. So that's the mentality that Burlamaqui is putting into here as well. If you're going to have it for mentality for individuals, you got to have the same for groups of individuals or nations. To have a just reason for war is not sufficient that we are afraid of the growing power of a neighbor. All we can do in those circumstances is innocently to try to obtain real caution that he will attempt nothing against us, and to put ourselves in a posture of defense. So again, the principle of self-preservation, a strong defense is the best offense, not the other way around. But acts of hostility are not permitted except when necessary. And they are never necessary so long as we are not morally certain that the neighbor we dread has not only the power but also the inclination to attack us. We cannot, for instance, justly declare war against a neighbor purely because he orders citadels or fortifications to be erected, which he may some time or other employ to our prejudice. So just because they have weapons, if they have weapons that we think are dangerous and they might use them in the future, we're punishing them for owning a weapon. And that's the mentality of gun grabbers for individuals as well. Oh, you're not allowed to own this. No one is allowed to own this because someone might use it in a way that is evil. And that's how Thomas Paine basically took this same type of approach. If there is a sin superior to every other, it is that of willful and offensive war. That's Thomas Paine's mentality. Now, I don't really have any personal insights into the views of Christian Wolff, who's one of our top 5 in this pantheon, because I have not read his work other than just a few brief excerpts here and there. But he's really important, and I don't want to skip over them because his work was the foundation. And I'll link to Liberty Fund, which has a lot of great resources. They don't have his book available for free, but I'm sure if you look up The Law of Nations Treated According to the Scientific Method, we're getting into some kind of Newtonian type stuff here. Of course, that was one of the forgotten. Newton was one of the greatest influences on the founders. But if you want to read it, I'm sure you can look it up online and find a copy of the full text and read through it. But his work was the foundation for the next person, and maybe the most important one to the founders, and that's Emer de Vattel. And here from Wiki, they point out that it was his seminal work, The Law of Nations, was largely influenced by a book titled The Law of Nations According to the Scientific Method by Christian Wolff. In fact, his work began by translating Wolff's text from Latin and then adding his own thoughts. So his original project was, I'm just translating this work, and I'm going to add some notes to it as well. But he eventually he expanded his work on this, focused largely on the rights and obligations of citizens and states. He was also influenced by another guy that I don't know, Gottfried Wilhelm Leibniz, but also Hugo Grotius. Vattel's work also had ramifications for just war theory, as it outlined international diplomacy as we now know it. He had this thing that he called the golden rule of sovereigns, and that is, one cannot complain when he is treated as he treats others. And I think that's kind of a foundation for the mentality of understanding, not agreeing with blowback. Because if you're messing in the affairs of other people, sooner or later, they're going to mess in the affairs of you and your people. So we shouldn't be surprised when an aggressive foreign policy results in, well, aggressive responses or attacks from other people. And here from Liberty Fund, one of Vattel's teachers was, surprise, surprise, Jean-Jacques Burlamaqui. And it was under Burlamaqui's tutelage that Vattel first studied in detail the principles of natural law and the law of nations. That's from Vattel, Life and Works. Now, here's Nadelson pointing out some of the reasons why Vattel was so important to the founders. First, he said, he was the most recent of the 5 great authorities. I think it was 1758 when he published it. Second, his book was comprehensive and readable. If you're going to read any of these, that's the one to start with because it builds on all the other stuff. It is the one that was most implemented by the founding generation, most understood, and most used as the basis for many of the legal terms and the policies under the Constitution. So start with Vattel. So it's most readable. Third, he was a strong advocate for individual liberty. So they're definitely on board with people who were supporting individual liberty. And fourth, he discussed issues that, while not always part of the law of nations, were very important to the founders, like the nature of confederations, the superiority of constitutions to legislatures, the need for one and only one person to supervise the executive branch. Benjamin Franklin was not a fan of that, and so forth, just as a quick aside. He's also cited pretty extensively by a guy that I cite pretty often that you may like, Lysander Spooner. In, I think it was 1860 or 1862, he wrote The Unconstitutionality of Slavery. He cites Vattel pretty regularly. Here, for example, Not an example of Lysander Spooner, but here's Vattel talking about neutrality. There's so many times foreign policy today, the U.S. is basically pretending to be neutral, but they're definitely one of the war belligerents if we're looking at the founder's view via Vattel. Because if you're going to be neutral, you have to actually observe certain principles. And here's how Vattel put it. Neutral nations are those who, in time of war, do not take any part in the contest. None. But remain common friends to both parties without favoring the arms of the one to the prejudice of the other. So if you're going to be neutral, just as John Jay said as Chief Justice, until war is constitutionally declared, the nation as a whole must observe and preserve peace. That means without a declaration of war, you can't start supporting one side or the other or both in a war, because that is you're no longer neutral. You are now a belligerent in the war, even if you're only doing it through, well, logistics support, providing arms and ammunition and things like that, if it's not done totally equally. But Vattel points out that you can't even, that's impossible. Anyways, he said, as long as a neutral nation wishes to securely enjoy the advantages of her neutrality, she must in all things show a strict impartiality towards the belligerent powers. For, should she favor one of the parties to the prejudice of the other, she cannot complain of being treated by him as an adherent and confederate of his enemy. So you're basically a confederate of one side if you're supporting one side with logistics and weapons and money and things like that. You are a part of that war, even if you are not super active in fighting it. Her neutrality would be a fraudulent neutrality of which no nation will consent to be the dupe. And so Vattel goes a little further here. Let us therefore examine in what consists that impartiality which a neutral nation ought to observe. And again, I'm just highlighting a couple of pieces that I think are really interesting, and I encourage you to read more on this. One, so as it relates to war, there are two things that have to be done to prove you are neutral. And if you're not neutral, then as John Jay said, you have to have a declaration of war to be engaged. One, to give no assistance when there is no obligation to give it. None. Nor voluntarily to furnish troops, arms, ammunition, or anything of direct use in war. Now, check this out. I do not say to give assistance equally, but to instead to give no assistance. For it would be absurd that a state should at one time and at the same time assist two nations at war with each other, and besides, it would be impossible to do it with equality. So the picking and choosing, we're going to give some funds, some aid to this side while we provide some jets to this side. We're going to send some troops, or we're going to run some logistics. You can use our satellites. Maybe we'll have our ships guard you, whatever it may be. This is literally choosing a side. It is not giving assistance equally. It's impossible to do. And in order to be neutral, in order to not trigger the declaration of war clause requirements, as John Jay pointed out, you give no assistance to either side in war. Now, if you want to choose one, that's fine. Well, not always. But it should be. That's available to do under the Constitution. It is not the executive branch choice to make. It is up to the representatives of the people and the states to make. They did not want a single person to make this type of decision. 2, in whatever does not relate to war, a neutral and impartial nation must not refuse to one of the parties on account of his present quarrel what she grants to the other. So if you're selling certain products to or allowing certain products to be sold or transportation to go through, you can't cut that off because they're engaged in a war with another nation. That's picking sides. Anyways, he goes a little further, talking about declaration of war. The right of making war belongs to nations only as a remedy against injustice. It is the offspring of unhappy necessity. Now, again, all of these people, they were not into rushing into war. And if we go all the way back to Grotius, the idea that nations would rush to arms for the smallest slight was barbaric. And that is in many ways, just because it's more technologically advanced and we don't see fields of blood in our homeland, this certainly is barbaric in the way a lot of people approach things today. This remedy, he said, is so dreadful in its effects, so destructive to mankind, so grievous. War is so grievous even to the party who has recourse. So even if you're morally justified in going to war, He's still saying, like, don't rush to it because the effects of war, even when you're in the right, are absolutely awful. There is no such thing as a wonderful war. It is an unhappy necessity at best. He said, unquestionably, the law of nature allows of it only in the last extremity. That is to say, when every other expedient proves ineffectual for the maintenance of justice. And we can see this type of mentality in James Madison's take when he says, of all the enemies to public liberty, war is perhaps the most to be dreaded because it comprises and develops the germ of every other. And I'm basically paraphrasing here, but it basically said from war you get armies. From armies you get debts and taxes, and armies and debts and taxes are the known instruments for putting the many under the domination of the few. There's absolutely nothing that helps us get this essential foundational information out to more and more people, more than the financial faith and support of our members. And while you're here, I just ask you to please consider joining us as a member today. You can jump in and participate and support us for as little as $2 a month. You got a couple of bucks of that dirty government fiat. You can head over to 10thamendmentcenter.com/members. You can also choose other options. There's annual, lifetime, 5-year options. Again, 10thamendmentcenter.com/members. And while I'm here, I want to say a huge but very quick thank you to just a handful of people who have joined us as members lately. There's Nancy in New Jersey, Brian in Texas, Cynthia in Arkansas, Donald also in Texas representing. A lot of times we have a lot of Missouri and California, but Texas lately, that's pretty cool. Brent in Iowa, Karina in Idaho, all beautiful places, all awesome people. I'm very grateful for your support and any consideration you can give to joining us as well. I'd be very grateful. You can also help us spread the word, taking actions on a lot of the mainstream platforms, whether it's leaving a comment or a review on a podcast platform like Apple Podcasts, or leaving comments, especially in the archive, subscribing, getting notifications, smashing like buttons. All that stuff can trigger algorithms and tell the platforms to show us to more people. I'm running a little bit late today and got a few things to take care of, so I'm not going to be able to take a look at the live chat until a few hours later. But please do continue leaving comments, whether it's live or in the archive. I appreciate your feedback and learn so much about things that I should do for future episodes from your feedback and suggestions. You can also email me at team@10thamendmentcenter.com. I really appreciate you being here. I hope you enjoyed the episode as much as I enjoyed sharing this with you. I hope you have an awesome day, and I hope to see you next time here on the Path to Liberty.